your military skills, you are a deadly weapon and are not subject to the same laws as other people that are provoked because you can respond with deadly force.
We're the Armed Attorneys. Today we're talking about whether your hands qualify as deadly weapons. Now, stick around for our attorney pro tip at the end about what you should discuss with law enforcement. Let's say you've been involved in a self-defense incident, and about your specialized training. But before we begin, show your support for the Second Amendment by hitting that like button. And to begin our conversation, we get this question all the time about, I have specialized training, maybe I have mixed martial arts, or I was in the military, and does that make me a deadly weapon? Are my hands deadly weapons? And how do the courts look at this?
Yeah, so I think we go back to sort of our general definition of what makes a deadly weapon. And bear in mind, it's going to vary slightly on a state-by-state basis, but I think in having reviewed virtually every state's definition, they all come down to a pretty simplified sort of concept that we can talk about here, which is that a deadly weapon is anything that's capable of causing or does cause serious bodily injury or death. And this can vary. I mean, we've had clients whose teeth were alleged to have been deadly weapons.
Yeah.
We've seen everything from, there was one case where it was a statue of a baby Jesus was alleged to be a deadly weapon here in Texas.
And that's, that's something the courts are going to look at. In the manner that something is used, does it cause serious bodily injury or death? So think about like a pillow. Mm-hmm. A pillow is not a traditional deadly weapon. But if you hold it over somebody's face and suffocate them to death, then in that instance, yes, that pillow is going to be considered a deadly weapon. So it's all about how you use it.
Exactly. So then the question is, I am highly trained, I have combat training, I've got martial arts training. Does that make my hands deadly weapons? And ultimately, at the end of the day, we have to return to this definition. And bear in mind, there's no database. People sort of talk about their hands being registered as deadly weapons. That there's no such thing, right? So we have to return back to this definition, which means that potentially, right, everyone's hands or no one's hands are deadly weapons because it depends on what you did with them.
Yes, and I think that brings us to our attorney pro tip of the day about whether you should mention your specialized training to law enforcement. Let's say you've been involved in a self-defense incident and police are on the scene. Is that the time to say, hey, I'm a black belt, or I'm in the military and I've received specialized combat training? And what we say on this is speak to your attorney first. We can see where, that might aid your case, but there are so many scenarios where that may not be in your best interest.
Right. And particularly on scene. Let's say you just have to kill someone with your bare hands in self-defense. You don't want to be rattling on things about you like that. There are lots of instances where that's just going to look weird.
Right.
It's going to set off alarm bells in the minds of police officers, prosecutors. And again, your attorney, a lot of what we get to do as defense attorneys is shield information. And it doesn't mean that we don't want it to come out. It means we want to control exactly when and how it comes out. Don't take that opportunity away from your lawyer because it's really important strategically to your case.
Well, we hope you enjoyed this content. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And keep your questions and comments coming below. Until next time, we're the Armed Attorneys.